morning, everybody. This is John Giardinelli. I'm your association's attorney, and we're going to do this week's rant on 3 different topics I'm going to cover very quickly because in talking to your professional standards manager, the sense that I get is that we've been having some issues with just some misunderstandings on 3 subjects: teams, the mediation clause in the R.P.A, and liquidated damages. So this is not going to be meant to be a deep dive into any of the 3, but just some things that are coming up that really you need to understand and do better. The first one is teams. The most important issue, and the thing that I see all the time in my real estate law practice, and that others see and that Lori hears about, is the fact you've got to understand you are not independent of the brokerage. You have a broker. You are simply, instead of an agent, you are a group of agents who are working in the brokerage, and you're still part of that broker and brokerage, and you are not independent. That means that the broker needs to understand that even if he or she has very successful teams, that broker still has a duty to cooperate, to supervise in all aspects that the law requires the broker to supervise. We had a recent conversation with the deputy commissioner who is in charge of legal, and the lack of broker supervision is critical. There's actually in one of the most recent bulletins a really great article on what broker supervision means, and clearly teams are included. Another area where teams get into a lot of trouble is in the area of advertising. Again, you cannot advertise independent of your broker. You've got to notify on all of your advertising material, the brokerage, the name of the broker, however that needs to be done. You need to make sure that it's clear that Team Smith or Team Jones or whatever it is a brokerage, or excuse me, is a team that is part of a brokerage. And if it's written advertising, whether it's a flyer, whether it's your business cards, there needs to be some indication of the name and of the broker. The broker has an obligation to make sure that you comply with the code of ethics, right? And that all the team members need to be understanding of the code of ethics. You need to understand issues relating to employment. A lot of the teams now are successful enough that they have their own staff. Some have even incorporated, and the staff then becomes employees, and all of the California employment laws need to be dealt with. And in some cases, it's very conceivable that the person that is the employee is an employee of both the brokerage and the team. Additionally, if there are people who are acting as agents but are paid specific salaries, those salaries might render that person to be the employee of both the brokerage and the teams. And that includes staff, transaction coordinators, unlicensed assistants, anyone that is responsible needs to understand the issues relating to both independent contractor and employment. Also, and I can't stress this enough, you need to have a written agreement. If I were the broker of the brokerage, I would require, not suggest, but require that every team have a written contract. Now, some teams can't afford to hire a lawyer to do that. I understand that, but CAR has a team contract. One of the issues that needs to be resolved are the management issues. Who's going to manage the team? Who's responsible for what? And the second issue has to do with the finances, right? We have a couple of cases pending right now where I'm a member of a team. I share in whatever the financial rewards are, but then I leave the team. But then there's transactions that are still in the pipeline. And in one case, the person indicates he's, because of the reputation of the team and all that, he's entitled to long-term income. And now they're at each other's throats, and there's expensive litigation. The broker gets sucked in. You got to understand that all that has to be worked out. CAR has a pretty good team form. You can either use it or use it and then modify it with some individual stuff. But it's very, very important that you have a written, not a verbal contract, but a written contract, and that the broker be allowed to review it and approve it. This is going to become even more critical as we move towards a change in the way compensation is paid. Most of you have been hearing about these commission lawsuits, and that's going to impact teams in some very special and significant ways. So again, all of these things, the use of artificial intelligence, all of these things are critically important. And then lastly, is the issue of names. You need to understand how the teams can be named. Number one, at least one team member's surname needs to be in the name of the team. So it could be the Giardinelli team. The word team, group, or associate needs to be part of the team name. So it could be the Giardinelli team, the Giardinelli group, or Giardinelli associates. However you want to do that. So you have to have a surname of one of the members of the team. I don't care which one, and it has the word group, associate, or a team in it. It's not independent from the broker again, and the advertising is critically important. At least one team member's license needs to be part of the advertising, and so does the name of the broker. So again, there's a lot going on with teams. There's some good quick guides that CAR has that are available to you. And there's nothing wrong with teams. They are happening. I suspect they're going to grow. And just depends on how your business model looks. But it's okay to have a team. Just do it correctly, or find yourself in trouble with the Department of Real Estate, and possibly even civilly. So, and again, brokers, you need to remember that you're still responsible for that team. Let's move on to another topic, and that is, it's a topic that is becoming more important than ever before: the mediation clause in the R.P.A. Mediations are up 29% in California, close to 30. Mediations that don't settle are up 10%. Litigation, I mean, and therefore mediation clause is more important than ever. Mediation is not arbitration, it's not even close. Mediation is nothing more than a settlement conference that is overseen by a judicial officer, a retired lawyer, a practicing lawyer, or a trained mediator. A third party is brought in, hired, appointed, however it's worked out, hired and appointed, and that person's job is to try and get the parties to settle. It's not mandatory that the case settle. If the case doesn't settle, then it moves on to litigation or arbitration. We hear a lot of people saying, you know what, I got to arbitrate. No, unless the arbitration is initialed, that is completely different. They actually made a pretty substantial improvement, I think, in the R.P.A. by separating the mediation clause, giving it its own paragraph number, and then arbitration is separate. Aside from the fact that you must try and settle a case, which is good for everybody, because if the case settles, you save all the money on litigation, all the stress of litigation, all the impacts that litigation brings, and there's not a winner, there's not a loser, there's parties that have reached some type of an amicable agreement. It's also important to understand that if you're going to bring a litigation or an arbitration, you must must offer mediation before you file any type of a lawsuit or an arbitration. If you fail to do that, you are going to be barred from collecting attorney's fees in the case. So if I hire a lawyer, I go straight into litigation, and I win, and my attorney's fees are, pick a number, $25,000, $50,000. I don't get those attorney's fees as part of my judgment. Whereas if I lose, the other side does. And so you really want to be careful about making sure that your clients understand mediation. Again, CAR has some pretty good resources. I'll probably do a rant in the near future on a more detailed look at mediation. And I want to tell you that the only real exceptions are set forth in the R.P.A. There's a section on preservation and or exceptions. Let's say, for example, that the statute of limitations is going to run. I can file my lawsuit to toll the statute of limitations, but I don't serve that lawsuit until I offer mediation. If I need to tie up the property, I need to have a receiver appointed, or I need to file a lis pendens, I can do that, file the lawsuit, record the lis pendens, do what I need to do to preserve whatever rights I might have. But before I go forward with the litigation in any way, shape, or form, I must first offer mediation. So again, I want to make sure you understand that the mediation clause is separate and apart from the arbitration clause. It must be offered, and although the vast majority of cases that do go to mediation do settle, the mediation clause does not require a party to pay anything, does not require a party to leave with a resolution. And if the cases don't settle, nothing in the mediation is going to be discoverable or usable by either side in any subsequent litigation. That leads us to the third topic for today, and that is liquidated damages. Liquidated damages actually is a term that's very common in construction contracts. It's where the parties agree that the damages are going to be very difficult to ascertain in a litigation. For example, I'm a buyer, I put down a deposit, and then I breach the contract. The seller is going to have a very difficult time establishing what their damages might be, right? Because the damages would include delays, additional fees, additional payments, all of those things. But on the other hand, does it really include problems with closing my second leg transaction or those kinds of things? And how do I justify damages if the property goes up in value? So what is common in a construction type contract has now been made available in the R.P.A. And basically what it does is it sets damages in advance in the amount of the deposit up to a certain number. It's not automatic. It's like any other damages. It requires a breach or it requires a default. And so that's the first question. Things like, were contingencies removed properly? Were there breaches in closing on time or at all? Were the parties acting in bad faith? And did the buyer in some manner default on closing? So if that's the case, then we have a potential default. If we do, then we look to liquidated damages. Liquidated damages in residential transactions are almost always the amount of the deposit. California, you cannot have almost all the time non-refundable deposits. In fact, it's inconsistent with the language of the R.P.A. So these are not non-refundable deposits. These are simply deposits that are used to cover the seller's damages for a buyer who defaults, doesn't close on time, removed contingencies and then fails to close, etc. It must be in writing, which is why in the R.P.A. there is a place for the buyers and the sellers to initial the liquidated damages clause. In a residential transaction in California, by residential I mean a 1 to 4, the amount of the deposit is capped at no more than 3% of the purchase price. So if the purchase price is like $100,000, the amount of the deposit cannot exceed, well, that's not true. The amount of the liquidated damages cannot exceed 3%. If the deposit is 10,000 and 3% is 3,000, then 7,000 is returned to the buyer and the rest is to be kept by the seller. If the deposit is increased during the transaction, let's say, for example, we agree to a 1% deposit at the conclusion of the negotiation for the purchase and sale, but we agree that when contingencies are removed, the deposit will go up to 2%. There's a form for that because, again, it must be in writing. So there's a form for that. It's the increased deposit form, the DID. And so that's the form that you would use. And the way that it can be enforced, if the damages are less than 3%, less than $10,000, you can go to small claims court. That amount is increasing on January the 1st to $12,500. So if my deposit is $12,500, there is a paragraph in the purchase contract, the R.P.A., that says if in fact you can go to small claims, then you do not need to mediate, you do not need to offer mediation, and you do not need to arbitrate. You can simply go to small claims court. So again, that's essentially liquidated damages. It's just a preset amount of damages equal to the amount of deposit, not more than 3% of the purchase price. There still must be a default or a breach of contract. And if the parties cannot agree on disbursement of the liquidated damage amount, the deposit amount, then you go to court. If it's above 10,000 today, you do have to offer mediation. You do have to offer the arbitration if you initial those paragraphs. And if it's less than 10,000, 12,500 on January 1st, 2024, then you can go to small claims court. Well, that's John Giardinelli's rants for today. Stay tuned. We're going to be talking in the near future about some new laws. We're also going to be talking about the litigation that's going on back east over your commissions. So for now, John Giardinelli and his rants are signing off.